what is the value of justice? My name is Abi Adams. I'm an economist at the University of Oxford, and together with my colleague in the Oxford Law Faculty, Jeremiah Prassel, we investigate the economic incentives at play in the justice system.
In 2017, our research resulted in the whole system of UK employment tribunal fees being scrapped.
I want to understand how we can best design the courts so they run as efficiently as possible whilst maintaining access to justice.
The world of employment tribunals, it's an interesting one. There's a big change today.
In 2013, fees of up to £1,200 were introduced for bringing claims to the tribunal. The effect was dramatic. Within months, claims fell by over 70%. Although there were fee waivers in place for people with very low incomes, many people were concerned that the fees made it too difficult for workers to enforce their rights.
So that's a very dramatic fall in cases where individuals are bringing claims for the wages that they haven't been paid, the holiday pay that they haven't got, or complaints about unfair dismissal, discrimination, the sort of common or garden claims that a Citizens Advice Bureau or a law centre or a solicitor's firm will see every day.
Against this backdrop, we set out to research whether adverse economic incentives could be thought of as a barrier to justice. In English law, Magna Carta has guaranteed access to justice for centuries. It's a great lofty principle, but there's one problem with it. How can we translate it into an actual hard empirical test?
To do this, we had to develop a new approach, combining economic theory and statistical analysis with constitutional legal principles. We drew on a range of data sources to show that because employment disputes generally involve small amounts of money, the fees often made it irrational for a worker to pursue a claim, even if they had a good chance of winning. Our research became a central contribution to the court case brought by Unison against the fees, which was heard by the Supreme Court in 2017.
There's an economic theory that underpins this called the theory of rational choice, which is developed in a fascinating article in the Modern Law Review by Adams and Prassel, and they have teamed up to produce an article which addresses the lawfulness and the economic rationality of the fees order.
The Supreme Court was swayed by these arguments, declaring the fees as a violation of the fundamental right of access to justice.
This resulted in an immediate impact on tens of thousands of claimants who might otherwise have been deterred from bringing their case to the courts.
Now the fees have gone. The most immediate impact has been that the number of cases has increased again, but a much wider group benefit from the halo effect of employers knowing that that's an option and that encouraging them to play by the rules in the first place.
We're now beginning to work on the design of online courts. How can we design a digital justice system that protects access to justice? A question best answered by lawyers and economists working together.